Welcome to this brief presentation focusing on the EU-US discussion around trade. We're going to discuss the EU's anti-coercion instrument, as well as the background to its potential application and the measures that the EU might take in response to President Trump's announcement of 25% tariffs on all products European. So the background is obviously that from the US side, there are various complaints about EU treatment of American companies, American products, American services. There is a substantial US deficit as it relates to the trade balance in goods. However, that is offset by an enormous surplus in relation to services being exported from the US to the EU. President Trump has also complained about EU regulation of big tech, the AI Act, the Digital Markets Act. He has referred to that as a form of taxation, and he's also warned of very big complaints within the EU that might result from it. This administration has forced close relationships with key players within big tech, like Elon Musk, Mark Zuckerberg, Jeff Bezos, Suchu, and that has even triggered media allegations of a broligarchy. And then there are major contentions around car tariffs, where the US imposes a 2.5% tariff on imported cars, particularly German cars being a significant export from the EU to the US, whereas in return, the EU imposes a 10% tariff on US car imports. And there are also quite high EU tariffs on agricultural products. As President Trump said, the EU have a large tax. They don't take our farm products and they don't take our cars, yet they send cars to us by the millions. So all in all, this has resulted in the announcement of 25% tariffs on imports from the EU into the US. In this short video, what we will address is what is this trade bazooka that the European Union, as well as various media, have referred to, the anti-coercion instrument. How does it actually work? What might the EU response to a 25% tariff hike on the US side look like? And what are the risks and opportunities for businesses to engage in this process? And as you have seen in the media, the EU has specifically referred to deployment of the anti-coercion instrument with statements like, if we are hit, we will react firmly, and all options are on the table. The ACI exists since 2023, and it is essentially, as the EU launched it and said, a new tool to fight economic threats and unfair trade restrictions by non-EU countries. It seeks to protect the EU and its member states and its companies from third countries seeking to manipulate EU policy. And it was very much caused by Chinese restrictions on Lithuania in 2021. That was one of the factors that resulted in ACI. But likewise, there was also the previous skirmishes, I would say, tariff skirmishes between the EU and the US under Trump 1 in 2018. So a brief summary of how the instrument works. Anyone, including businesses, member states, companies, operators, can complain about third country measures. And then the Commission will examine those measures to determine whether or not they are economically coercive, whether they are using economic pressure on EU businesses, EU trade, in order to convince the EU to implement a change in its policies. The Commission cannot take longer than 4 months to examine this. If the Commission then concludes that this third country measure is actually economically coercive, it will make a recommendation to the European Council, which is the representation of all 27 member states, to introduce an implementing act in which they determine that the measure is economically coercive, which requires a qualified majority. So 15 out of 27 European member states, representing 65% at least of the European population, must agree. The Council will act within 8 weeks of receiving the Commission recommendation, taking the total processing time up to a maximum of 6 months. The Commission will provide then opportunity for consultations with that third country in order to resolve the dispute, to see whether they can convince in trade negotiations the third country to let go of these measures. And that could be done by direct negotiations, international adjudication, potentially referrals to the dispute settlement body, or mediation, conciliation, or good offices by a third party. But where the third country does not put an end to its economically coercive measure within a reasonable period, which reasonable period is not further specified in the anti-coercion instrument, the Commission may then adopt union responsive measures. And it's important to realize that it is the Commission who can adopt those union responsive measures, so that does not require a council decision, which means that the executive of the European Union, the Commission, can decide standalone. Obviously, there will be close cooperation with the member states, but in the end, it is the office of the Commission that can actually make the decision. So what does the ACI target exactly? Economic coercion is situations where a third country, like in this particular instance, the US, is seek to pressure the EU or individual member states into making particular choices as it relates to trade, investment, and the policy and regulation applicable to it. There are a couple of factors that the ACI specifies that must be considered for the Commission to make its initial assessment to the Council whether or not a measure is coercive. In particular, the intensity, the severity, the frequency, the duration, the breadth and magnitude, whether the third country is engaging in a pattern of interference, seeking to influence or prevent particular acts from the Union, a member state, or even another third country, whether the measure encroaches on an area of sovereignty for the EU or a member state, whether it seeks to affect essentially an area of policy and regulation within the European Union, whether the third country is acting on the basis of a legitimate concern or not, and whether there are any attempts made before the third country adopted the potentially coercive measure to settle the issue in good faith to international coordination or adjudication. The Commission can then examine any third country measure, so there's no limit on what type of measures can be reviewed. It does not specifically relate to trade measures. Can be done at the Commission's own initiative, the European Parliament or a member state, but also, importantly, on request from EU companies. And this is important because in this process, there is influence for business, and there are options for European companies to seek to address the tariffs that the US imposes. Likewise, there are opportunities for American companies to make their arguments known to the Commission to the contrary. As I said, the Commission will have 4 months to conduct its examination, and then when it's satisfied that the measure is economically coercive, it will then submit a proposal to the Council, again, the 27 member states, to issue an implementing act to confirm that the instrument actually is coercive. That then opens the door for consultations with the third country, which should be resolved within a reasonable time frame, which again, as I said, is not specified. If that is not resolved within a reasonable time frame, then the ACI creates the opportunity for URMs, union responsive measures. So what measures are exactly available? There's the imposition or the reimposition of customs duties, but bear in mind, this is an authority that the European Commission has in any event, as it demonstrated in 2018 by imposing tariffs on American bourbon, American motorcycles, and other iconic US products. Could be restrictions on importation or exportation of goods vis-a-vis the EU and the relevant third country, restrictions on transiting goods from the third country through the EU. There could be public procurement, tender restrictions that might affect companies from the third country. There could be measures that affect the trade in services, access of foreign direct investment into the EU, protection of intellectual property rights, and restrictions on banking, insurance, or access to European capital markets and other financial services, as well as restrictions in relation to product conformity, REACH, phyto and veterinary sanitary restrictions as they apply to products from the relevant third country being placed onto the EU market. So there's a pretty broad range of measures that the EU can take, and that is maybe why this tool is so potentially powerful. So what might the EU response to 25% tariffs look like? There are many suggestions in media reports, as well as suggestions from EU officials, that the EU intends to use the arsenal of retaliatory measures under the ACI to target US services industries, bearing in mind that there is a significant services surplus as it relates between the EU and the US, particularly in respect of big tech. So an ACI response may well go beyond the 2018 EU response that was merely imposing more customs duties on iconic US products. There could be stricter licensing rules in the digital services sector. There could be the revocation of protection of intellectual property rights or the commercial exploitation of such rights, such as software downloads. And these are all measures that would directly impact on big tech. The timeline for an EU response is currently unclear. But we anticipate that the US might introduce tariffs on EU products fairly soon. So March 2025 is going to be a very important month. This is where the EU needs to reach decisions whether big tech like Alphabet, Apple, Meta comply with the Digital Markets Act. But likewise, it is also the time frame in which President Trump has announced to impose tariffs on the EU. So, what does this mean concretely for business? First of all, it's relevant to map out supply chains. Even in the event that the EU doesn't use the anti-coercion instrument, it is important to realize how your supply chain is built up, where there is potential exposure to tariffs, either on the US side or on the EU side, and develop contingency plans and potentially options to diversify the supply chain. This is, of course, closely related to a cost assessment of any such changes in the supply chain. Secondly, businesses can themselves engage with the ACI process to identify and to flag to the European Commission how potentially the US tariffs concretely affect EU businesses, but also to respond to requests for information published by the European Commission during their first initial fact-finding review of potentially coercive measures. And also to engage with the European Commission as it relates to the responsive measures, what measures would best represent the interests of a particular business or industry, and which potential response measures would not be to the advantage. And this process is, of course, open for participation for European companies, but equally can be used by US companies to also make sure that their interests are at least heard or informed within the whole process. So thank you for bearing with us and listening to this presentation. We hope we've been able to give you some useful insights into this new trade bazooka and how it potentially could affect the EU-US trade relationship. If you have any questions or want to seek more information about how ACIN can help you navigate this trade war, please do not hesitate to reach out to your usual ACIN contact or contact Chiara Clowie or myself, Jasper Helder, in our London office for further discussions. Thank you.